I am Joseph Langlois, the Associate Director of the Refugee, Asylum, and International Operations Directorate within USCIS at the Department of Homeland Security. My testimony today will focus on how USCIS supports U.S. efforts related to border security while upholding our refugee protection obligations. The United States has a long and proud history of providing humanitarian protection. We are signatories to the 1967 Protocol relating to the status of refugees, which bars contracting states from returning refugees to their countries of feared persecution. Our obligations under the Protocol are primarily implemented through our nation's asylum process, which involves proceedings under two tracks: one in which an individual applies for asylum affirmatively with a USCIS asylum officer, and the other in which an individual seeks asylum before an immigration judge under the Department of Justice. In addition to the interior asylum process, the process that is more directly tied to border management is the credible fear screening process, which will be the subject of the remainder of my testimony. Prior to the immigration reforms of 1996, all individuals apprehended attempting to enter the United States unlawfully were placed in full proceedings before an immigration judge. These proceedings were time-consuming and resource-intensive. Individuals in such proceedings were generally not detained. The 1996 reforms allowed for the expedited removal of individuals without proper documentation or those apprehended close to a U.S. border shortly after an illegal entry. All individuals placed in expedited removal proceedings are subject to mandatory detention and prompt return to their countries of origin. In creating this new removal process, however, Congress was mindful of the United States treaty obligations to the status of refugees and created a screening process known as credible fear to prevent persons from being returned to countries in which they would be persecuted or tortured. The USCIS Asylum Division administers the credible fear program. Persons subject to expedited removal who indicate a fear of return are referred to a specially trained USCIS asylum officer who conducts an in-person interview to determine whether there is a significant possibility that the individual will be found eligible for asylum or withholding of removal. This determination does not confer any immigration benefit. It is simply a screening process employed to identify potential refugees. The final decision for asylum eligibility rests with an immigration judge. Credible fear interviews are conducted by USCIS while the individual is detained. USCIS conducts security checks, including biographic and biometric checks. If USCIS determines an individual does not have a credible fear, he or she is subject to immediate removal unless the individual requests a limited review by an immigration judge of that decision. Those found to have a credible fear are placed into removal proceedings where an immigration judge ultimately adjudicates any applications for relief from removal. Simply put, they get their day in court. Credible fear screening standard was purposely designed to be a low threshold, requiring only a significant possibility that an individual may be found eligible for asylum or withholding of removal. Historically, 87 to 98% of individuals who are placed in expedited removal do not express a fear and are not subject to the credible fear screening. A small percentage of individuals placed in expedited removal who do express a fear of return and are subject to the credible fear screening, the majority can meet the low threshold that is established before they get their day in court. The expedited removal process is a critical tool for effective border management. The credible fear screening process supports the continued operation of these indispensable border efficiencies by providing a mechanism that ensures U.S. compliance with its international treaty obligations relating to refugees.